Hello guys, I'm Andrew again from Seoul Law Group, and we're an English-speaking law firm based in Seoul. Today's video will have an in-depth look at everything you need to know about the Korean inheritance law. For most foreigners, the Korean inheritance law will not apply, but there are a few instances where it will. This video is here to give you a brief overview of what the Korean inheritance law will cover and will help you navigate the system. In many cases, Korean inheritance law will not be applied when it comes to foreigners, as they will fall under the Act on Private International Law. There are some instances where the Korean inheritance law will be applied. For instance, when a foreigner's parents have the Korean nationality, when a foreigner obtained the Korean nationality, when a foreigner who owns real estate in Korea specified using one of the methods of will that the Korean inheritance law should be applied in their inheritance. Foreigners do not need to fly into Korea to deal with inheritance. It is possible to appoint a lawyer like Seoul Law Group who will handle your case. Korean inheritance priority. The Korean law reserves portions of the inheritance for each qualified heir. If no will was made up, the reserved portions will be granted to the heirs in the following order. 1. Lineal descendants of the inheritee. 2. Lineal ascendants of the inheritee. 3. Brothers and sisters of the inheritee. 4. Collateral blood relatives within the fourth degree of the inheritee. Lineal descendants means children, grandchildren, great-grandchildren, etc. Lineal ascendants means parents, grandparents, great-grandparents, etc. It should be noted that unborn fetus usually do not have legal rights because they are not human yet, but lawmakers often make an exception for them when it comes to inheritance. Unborn child still counts as lineal descendant, and they are treated as if they are already born. In case there are multiple people in the same rank, the priority goes to the one with the closest relationship. If there are multiple people in the same rank and the same degree of relationship, then they become co-inheritors and receive equal shares of the inheritance. Not only the assets will be divided among the heirs, but also the debts. Surviving spouse's inheritance rights. The spouse becomes co-inheritor with any inheritors in the first and second rank. If there aren't any inheritors in the first and second rank, which means the deceased didn't leave any children or parents, then the spouse becomes the sole inheritor of the deceased. Also, when the spouse becomes a co-inheritor, they get 50% more share than those of the other inheritors. The Korean law is protective of the spouse who is left behind. Inheritance by representation. We looked over the basis of share of inheritance, but it becomes complicated when a child predeceases their parent but still leaves a spouse or a grandchild behind. The Korean law passes on the inheritance if the child dies before the parents. This is called inheritance by representation. It should be noted that when the spouse remarries, inheritance passed down from the deceased spouse cannot be claimed. Infringement and recovery of inheritance rights. Upon the death of the deceased, the ownership of the estate is automatically transferred to the heirs. Therefore, this does not require any further legal actions. If there are multiple heirs, they will share the ownership of the estate. But still, it is possible that inheritance rights be infringed when an heir takes a bigger portion than what they're entitled to, or if a person who doesn't have inheritance rights takes ownership over the estate. In case of inheritance right infringement, the lawful heirs can file a lawsuit, but this needs to be filed within 3 years from when the infringement was found out, or within 10 years of the infringement happening. The court will analyze the claim, and then when this is accepted, they will order the infringer to return the property to the lawful heirs. The size of inheritance share. Even though each heir will receive a share of the inheritance, the calculations of the share size is not a straightforward process, especially in the case when one of the heirs has received a big gift from the deceased, or when one family member has supported the deceased financially or physically during their lifetime. There are two types of mechanisms to prevent unfairness towards the heirs. Contributory portion. Contributory portion is granted when any of the heirs have provided the deceased with any special care, financially or physically, during their lifetime. Let's say the deceased has 3 children, but only one child financially supported their parents in their old age, visited them often with gifts, or pay for the parent's medical fee so that the parent didn't have to pay for it. This child has a right to receive more inheritance than the other two children. The Korean law leaves it up to the heirs to agree on who shall have a contributory share and how much this would be. If the heirs are unable to come to an agreement, the Korean court will be making the decision. Special benefit. In case one of the heirs has received a significant gift from the deceased before their death, the Korean law will consider this as being a prepayment of the inheritance, which means their inheritance will become smaller than other heirs. Let's say the deceased has 3 children again, but the deceased only sent one child to an expensive university or gave that child a large amount of money to get married or start a business. That child should get less inheritance than the other 2 children. Again, all the heirs have to come to an agreement, and if this agreement can't be reached, the Korean court will be making the decision. Korean will. All of the above occurs only when the deceased didn't leave any will. So, to avoid complicated legal dispute after your death, it is recommended to make a will. According to the Korean law, there are 5 ways to make a will: holograph document, sound recording, notarial and secret documents, and instrument of dictation. If no will has been prepared, the rule of interstate succession will be used to divide the inheritance. When a will is present, a person who normally wouldn't be categorized as an inheritor by law can also become a beneficiary. Even though a will is present, this doesn't mean that certain lawful heirs can be excluded from receiving their lawful share. Disinherit a family member. Currently, the Korean inheritance law does not allow a will to completely overrule the Korean law. Lawful inheritors will always be able to receive the minimum statutory share. This law was created to protect inheritors from being disinherited or left with a very small portion of the inheritance. The elective share is equal to 50% of the interstate succession share. There are certain situations when the legal heir gets actually disinherited by the law. You can find a breakdown of these situations on our website. Link is in the description box below. Renounce Inheritance. In case you don't want to receive the inheritance, a renunciation of inheritance must be filed with the Korean court within 3 months from the date the heir found out about the passing of the deceased. In case the debts of the inheritance are bigger than the assets, a reserved renunciation can be filed within 3 months of when the heir found out about this fact. A reserved renunciation means that the heir only inherits the debts to the extent that the inherited assets can pay off. Korean inheritance lawyer. All of the information mentioned in this video are the basics of the Korean inheritance law. It is highly recommended to hire a Korean inheritance lawyer to help deal with the inheritance, and especially as a foreigner. Get in contact with Seoul Law Group, as we are experienced in handling Korean inheritance cases between Koreans, Korean families living abroad, and when foreigners are involved. A common mistake made by foreigners who are involved in an inheritance dispute is that they contact a Korean law firm too late into the process. This can have a negative effect on the outcome of the law case. When it comes to legal cases, it's highly recommended to involve a lawyer as soon as possible. Korean inheritance tax. Anyone receiving any kind of inheritance within 10 years of the benefactor's death is required to pay inheritance taxes. Tax rate is based on the market value of the estate minus deductions like debts left by the deceased and public imposts. Any property gifted shortly before death will also be included in taxable inheritance. Well, I hope this video was useful for you. If you have any questions or concerns about inheritance law in Korea, let us know in the comment section below, and you can find more information on soullawgroup.com. Don't forget to like, subscribe to our channel, and turn on that notification bell for more Korean law videos, and we hope to see you soon. Bye.